Preferred stock is very similar to common stock, except that it comes with a basket of special rights. And most of those rights are going to be around either economic rights or management rights. And so that may mean they get a board seat. The preferred holders get to vote on one person that goes on your board. It almost certainly means there's a liquidation preference, meaning if there's a sale of a business and it doesn't hit a certain hurdle, then the investors would get all of their money back before you received anything. I'm going to stick on this point for a second because it's fairly complicated, but it's pretty important. And I'll do it through an anecdote. So right now, I actually have a client who is in the process of selling his business. And it should be a pretty successful sale for him. The problem is, at one point, he had to renegotiate what his liquidation preference from one, which is the standard, to I believe it was 2.5, which is very, very high. And so what a liquidation preference means is that, and again, I'm just kind of very simple here and try to talk in the most general terms, but it basically means that if I'm a preferred holder, and let's say I put in all the money and I put in $100 million, if the business is sold for $100 million, I'm going to get all of that back because my liquidation preference is $100 million, right? So for the common holders to receive anything, the sale has to be above an amount such that I would receive all of my liquidation preference back. Otherwise, I'm just going to take it all. And so in his case, this very successful exit, again, it's very successful. This client is a little bit at a disadvantage because he essentially has to, 2.5x the investor's money before he sees anything, right? Because anything less than 2.5x, then the investors just take it all. Again, we're not, if you have specific questions about fundraising, I'm happy to get into it. I'm happy to go more into liquidation preferences, standards for board seat representation, whatever you want. Didn't really delve into it here because it seems a little bit premature, because my guess is that most of you are going to be doing one of the next two things, and that's either a convertible note or a safe.
Can
A
I
convertible, sorry, go
can I
ahead.
interrupt for just an
Yeah,
anecdote
please.
here for a second, Lynn?
Yeah.
Funny enough, don't know all the details, but Founder Institute actually kind of came out of some really high liquidity preferences and some other very investor friendly, not founder friendly terms that Adeo, the founder of Founder Institute, one of the founders, had started a business that became a unicorn before he was 30 years old. And I don't know, like fully, but essentially, even though it was very successful, the terms were so onerous from the VC side of things that he didn't make any money out of
No.
it. And so he started the predecessor to Founder Institute was basically a list of VCs, and like he was like the friendliest to work with and kind of like what various terms were. And Founder Institute ended up springing out of that entity. So just thought I would give a little bit of history.
Yeah, no, that's really interesting. And to be honest, and don't be discouraged, but that's not a terribly uncommon story. Now, I will say the good news is it's probably less uncommon now than it was when he was starting up, because now there's so much information available in terms of become so standardized that um, there's not the information disparity that I think really plagued early being
Yeah.
10, 15 years ago, founders who, when it was a bit more the Wild West. And so I'm sure it was a combination of um, probably being overly diluted, and a bad liquidation preference. And those two things together, and certainly if they, depending on what he did with convertible notes and safes, we see a lot of, founders get upside down with those. You can really get in a situation where everybody else in the deal can win except for you. Certainly relative to the amount of time that you'll be expected to put in and devote to it. Now, again, the good news is I don't think it happens as often now as it used to, because I do think that there's just like programs like this, for example, that just didn't exist, 10 or 15 years ago. Um, that's great that you're availing yourself of, but yeah, it's unfortunately, not surprising to hear that. But moving on to what I think oh, sorry, go ahead, Reed.
Sorry, well, one other thing, I don't know, just because if you can see it and you can decide if you want to take questions now or not, but Jane raised her hand, so I didn't know if you wanted to do questions now or
Oh, sure, I can. Yeah, that's fine. I didn't see it. Go ahead, Jane.
yeah.
Okay, great. Thanks so much. So I've been doing some reading up on this before we met today, and it's really dense and it's all really new to me. And it feels like there are so many ways to like mess up and have significant implications. And so you were getting to this, like, and maybe later on the presentation, are there like two or three like really simple steps, like make sure that you're reading everything, that your lawyer's looking at everything, to that in the early stages you're not going to miscalculate. Um, any advice there? And again, maybe you're getting to this so that I know what to be looking out for really early on.
Yeah, I mean, your lawyer looking at everything is helpful, right? I mean, that's, self-serving, but also true, right? I mean, a lot of these documents aren't complicated, um, but there are some less obvious pieces of them that can get missed. And so to work with a lawyer that's done it before, and can warn you of those things, I think is obviously really helpful. At the formation stage, candidly, if you're a single founder or you're like a 50-50 founder group, you know, I push people to use Clerky and other formation, online formation services all the time. Because for the most part, anything you mess up there, a lawyer can clean up, other than your 83Bs, which don't mess that up. Um, but when you start to get into fundraising, that's when I think it's really foolish. And I mean from the term sheet stage, not like don't negotiate a term sheet and then bring your signed term sheet to your lawyer. I mean before a term sheet is signed, because everybody thinks a term sheet, oh, that's just, it's not binding. It's the high level stuff. It doesn't matter. All the nitty gritty is in the docs. And that's actually not true. There's a lot in the term sheet that if you agree to a bad term sheet, you're stuck with it. Come time for the transaction. So when you get into this area, being financings, my personal, very biased view is, but also based on a lot of experience and seeing people that have gotten pretty upside down with it, is don't mess around. Don't try to do it yourself. Bring a lawyer in. And Clerky, I think, does safe rounds now. You can do it through Clerky, but I would at least consult with a lawyer while you do it, because again, it's safes seem really simple, hence the name. Uh, but the problem that we see with safes is that people sell too many. Like safes become this sort of, they're like magical paper that you give somebody a piece of paper and they give you cash, and then they don't actually own any equity, and it's never going to matter. And the truth is, what happens is that I think the biggest mistake we see with safes is that people sell too much relative to their cap, right? So you have to think about, like, if you've got a $5 million cap and you're selling $3 million worth of safes, you're selling a massive piece of your business, right? And so you really have to be deliberate about uh, about where you're setting your investment targets relative to the cap, and when you're going to draw a firm line and say no more. If I'm going to take more, it's going to have to be at a higher cap, or I'm just not going to take any more. Because that's probably, I don't want to say it's the number one issue generally, because there's lots, but from a financing perspective, that's probably actually the biggest issue we see with founders who come to us too late, is that they've oversold their safe round, and it's killed them. They're going into basically their first price round with already taken a ton of dilution. And if you're upside down that early, it makes it really hard to figure out how to do your future financing rounds so that you still have, this sort of stake in the business that the investors want you to have, so that you're motivated, to work for, frankly, in many cases, less than you're worth, to keep the business going. So
Yeah, I
those are probably my
think
two big ones. Yeah, go ahead, Reed.
just because I think that's overlooked a lot of times by founders who are starting out, like who don't understand sort of what an upside down cap table means. One of the real things you have to look out for is not just for your own stake in the company and kind of like protecting, like to make sure, but later investors will look and see how much ownership the founding team has. And if it is not a big enough percentage, depending on the stage, they're like, they are not going to be motivated to really give it their all. So I am not going to invest, period. So it's, and seen that time and time again with founders who've like had various kind of business, pivoted, try to like recapitalize, do all these like things, and it can just get really messy. So
100%. And when that happens at like series C, D, E, you can sort of figure that out, right? Because for a business that size to be successful, the founder stake, it can be smaller. But when you go like into your Series A and you have a big founding team and you've taken too much on safes, and all of a sudden everybody on the founding team has less than 10% ownership stake, that's a bad situation, right? I mean, the investors aren't going to want to put money into a business where that stake is going to get diluted and you're not, there's no exit coming for, at least 2 or 3 more rounds of fundraising, most likely on the low end. And so that 9% is going to go down even lower. And so, I think Reed's exactly right. Like, making sure that, again, not just from your perspective, but from making yourself attractive to investors, not over committing yourself in these early rounds becomes just dramatically important. Okay. So, and I can't actually, let's see, am I able to look at yeah, sorry.
what are you
So,
looking for?
I just saw the chat.
Oh yeah.
Yeah.
Yeah, I don't know if you want to comment. I literally like I know these programs exist, but like, the various,
Yeah. I mean, to me, in terms of the formation sets, um, they're all pretty good. Carta, Pulley, Clerky, Angel's got one, JP Morgan's got one now. They're all pretty good. I tend to think that Carta for cap tables, and it doesn't really matter what you do for the formation set as long as don't do LegalZoom. Reed's heard me go off on this. Don't do LegalZoom. LegalZoom is a huge mistake. Um, but if you do one of the formation sets that's directed at startups and you follow it pretty closely, you'll be fine. As long as you get your 83Bs in, most things can be sorted out after the fact. But yeah, don't do LegalZoom because they're not aimed at startups and their sets are just a disaster. But everything else is pretty fine. Carta, I tend to think makes sense from a cap table perspective just because everybody's so familiar with it. Pulley is getting a lot of market share lately, so I think that that's probably fine too. But investors, part of it is sort of catering to them as well, and making life easy for them. And so you can do something that's, a little bit more exotic because it's a little bit cheaper, but you know, I don't know. My view has always been, you sort of treat your investors like children and you make it as easy for them as possible, and you'll just save yourself a bunch of drama. Um, is 10% a good rule of thumb to not go lower than for founder stake? Uh, I don't. If that does that mean ever? Because I think the answer is probably no across the board, right? I mean, 10% coming into like your seed or Series A is way too low. But if you're talking about exiting, then you can, I mean, if you're a unicorn and you're going to have $1 billion exit, yeah, I would take 5% of $1 billion. Like it really just there's so many possibilities. But for our purposes, I'll focus on the early stage. And so I actually think that in your coming into your like Series A, I don't really have a rule of thumb because so much depends on how many people are on your founding team. Like, have you had to, you know, a bunch of pivots? And so I hate to like give a number that sort of like, you know, uh, I don't want to give you a number that's too low for your own situation, but I also don't want to give you a number that's too high for your own situation. So though I hesitate to give a number, I will give a number. I think 20%, if you're below 20%, coming out of your Series A, I think that that's when you're going to start to see um, a compression issue, right? Like if you're not above 20%, maybe a little bit lower, but I really start to think that that's when you like it just gets harder and harder um, uh, as the further dilution comes to keep up. But Reed, if you've got a thought on that, I'd love to hear yours too.
Not mine necessarily, but Peter Walker he's from Carta. He posts on LinkedIn. He's like their like data guy. This was a while back, but he had a graphic that like sort of showed founder stake by stage, like, like what
Mhm.
percent the entire founding team still owned at various stages, and shows like, I think like, the 25th percentile, median, and 75th percentile. So it gives you like, it can help to give you a range of like what is fundable. Um, LinkedIn is not the best way, but like literally what I do when I'm trying to find this stuff is I go to LinkedIn, I search for Peter Walker, and then I go through, he
Yeah.
posts once or twice a week, but I just like kind of scroll through until I find the one I want. So just, if you're looking for that information. By the way, also for people who are funding, like he's got really good, like I highly recommend following him on LinkedIn. Lots of good
And
data.
Brian, see, you're asking me the exact thing I didn't want to do.
Hmm.
No, you should definitely not expect to give up 75 to 80% of your total equity during Series A. So the the situation I had in mind would be a situation where you had multiple founders, right? So imagine three founders at 20% each. And so that's 60% total. And you've done a safe round, and then you've done your Series seed, and then now you're into your Series A. And so then you're coming out, you've probably taken at that point 40% dilution, and you're coming out. Plus you've got a stock pool for employees. So you're coming out at that point of 20%. And I really more mean sort of on an individual level. Um, so if you personally are at 20% coming out of your Series A, it's not the end, it's definitely not the end of the world. But as you get, as that number goes down, you're going to start seeing additional dilution every single round. And depending on if you do some, round extensions, if you sell additional safes, like, if there's any sort of like bump in the road, if there's any sort of like dilution that comes at a flat valuation, you start to risk that number getting what I think personally is too low by the time you get to like your B, C, and D round. But no, you like if for single founder companies, if you've given up 80% of your equity after round one, uh, you should there should be a problem. Their red light should be flashing. Um, okay. I think that's all the questions in the chat. Um, all right. So just finishing up this point about convertible notes and safes. Convertible notes, these were sort of an inelegant solution to the problem of not being able to value companies. And so it is a debt instrument. It's absolutely a debt instrument, and don't fool yourself that it's not. Um, that is intended to convert to equity at a later date. Now, there's two big problems with a convertible note because it's a debt instrument. One, interest, right? So all debt has interest. There's no such thing as a interest-free loan. Um, so it's got interest. So that's uh, a part of your business you'll be giving up without receiving cash for it. That creates issues. Two, it's got a maturity date. And that's really the bigger one, right? Because once that maturity date hits, that note can be called, and that can create all sorts of problems for you and all sorts of leverage issues for you with your investors. Um, it's funny. I think if we had done this or when we did this presentation last year, probably said, we don't really see convertible notes anymore for these reasons. In the last year, convertible notes have sort of, I felt like, come on strong again. We're definitely seeing more convertible notes. Um, that said, safes, which are the next one, which I'm hopefully you all have heard of at this point, are still the dominant form of early stage financing. So a safe, a simple agreement for future equity. It's a contract where you take money from your investor today and you agree at some later date. Generally speaking, it's the conversion, or excuse me, your next priced preferred equity round. That safe will convert into equity. And as I was saying earlier, the problem with safes are, well, let me actually start with the good thing. The good things about safes are it is the most efficient thing that we as lawyers can do for you. It is very simple. It's a form document. It's intended to not be changed. So there's, very little uh, uh, like bespoke work that happens on it. Um, and you can close a safe round on a rolling basis without any real issues. So, you can get a safe, you can start selling them, one-offs. And it's really simple and it's really cheap. And because of that, that leads to the one major problem, which is that, because it's simple and cheap, people think about it as not being real and not having, real consequences in the world. And so they sell too many of them. Generally speaking, a safe is, nowadays is going to have a cap. And what that means is that it's good, the value that it converts at is going to be capped. So if you're doing a price round and the value of your business is $10 million, but if you've capped all your safes at 5 million, all your safes are going to convert at a $5 million valuation, not a $10 million valuation. So the safe investors are going to get a significantly better deal than your other investors. Occasionally, maybe more than occasionally, but I don't think as much often as with a cap, you'll see a discount. And a discount just means some percentage off of whatever the sale price of the equity is in the next round. Generally speaking, it's about 20%. So what that means is that, for what an investor in the next round has to pay $1 for, your safe investor gets to pay 80 cents for. So they'll get more equity for the same amount of money when it converts.
Then
Again, so go ahead, Reed.
I just had a question on it too.
Sure.
Sometimes you see both, right? Like, and I think it's
Yeah.
confusing to people, like what that means, like when you have a cap and a discount. Can you
Yeah.
just
So
run
it's
through that real
funny.
quick?
You used to always see both. I guess like maybe 2 years ago, Y Combinator took the combined safe off of the site. Um, yeah, I don't know, just
Hmm.
because they, for whatever reason, I think maybe I think I heard it was because they thought it was too confusing. So maybe you're right, Reed. Maybe that's, maybe you're spot on. So you don't see it as often now because it's just not, it's not available in the same way. I mean, every lawyer has got a form cap and discount safe. Um, but what it means is that you calculate the price both ways, in whichever way is better the investor gets.
Got it.
So you calculate it with a cap, you calculate it with a discount, whichever results in more equity going to the safe investor, that's the one you use.
Okay, thanks.
No problem. All right. So a couple of other instruments that you may hear about, um, but again, that's not certainly not in every round. Warrants, these are similar to options. They're contracts to uh, buy um, a security at a later date. Usually it's, you'll hear like penny warrants. And oftentimes what that does is the effect of giving those penny warrants is to change the valuation, right? Like I'll give you a $10 million valuation, but I'll give you all these penny warrants. And so the effect of that is that when you exercise those penny warrants, you get a lot more stock. So your effective valuation spread across all the money you invested goes down. So that's typically, you know, in your context, if you hear somebody asking for like warrant coverage, you see that in venture debt. It's because they want these, it's generally speaking, cheap stock to sort of help sweeten the deal for them. Standard debt financings. Um, this is just borrowing money. Again, this has actually become more common recently. We didn't see a lot of this, particularly in sort of the, go-go years of the last, half decade. Starting to come back a little bit more. You know, with this, I would just be careful, right? Like these are real obligations, these are real creditors. They come with interest, they expect to get paid back on a maturity date. And your businesses may have trouble with cash flow in servicing the debt. So and a lot of times they're going to make you do a personal guarantee too. And I know we're all, believers in our companies as you should be, but I've just seen people get in a lot of trouble with this. So I would think long and hard before going the debt route, particularly if it's personally guaranteed. But oftentimes, particularly in a tougher market for equity capital, that's what you're going to be left with. Um, Crowdfunding, I'm sure you all know what this is. My only real comment on that is don't believe the hype, right? There are some businesses that are meant for crowdfunding, a business that has a sort of a large customer base or a large fan base and then decides to raise money, that's a great business to try to crowdfund with. But for your typical startup that's just launching, it's really tough. The algorithms on these sites are set up to sort of boost the um, the companies that are performing well. And to perform well, if you don't have a large fan base, you have to sort of seed the investment yourself. So this money that you could have taken without a fee, you're now having to push to the crowdfunding platform. So they're getting a cut of it just to boost you up in order to try to get, the benefit of the larger, market that comes there. So, again, the number of sort of your everyday startups that we see that are successful on these crowdfunding platforms is really low. But again, every situation is different. But I wouldn't go into it lightly, right? There's no free lunch, as they say. And again, this is just another situation where we see, you know, founders waste a lot of time and maybe some, room on their cap table for a very disappointing return. Um, and then ICOs, which maybe you've heard of, these are initial coin offerings. I'm not going to spend a lot of time. I don't know actually if there are any founders on this call who are thinking about doing a token. I'll just say that speaking of no free lunches, this is exactly that. Um, you know, Definitely consult a lawyer. This is a very fast moving area, and it tends to change with whoever um, the current administration is. And so, the last administration was very skeptical. This administration is signaling that maybe they'll be somewhat less skeptical. Um, but this is, there's a lot of ways you can really get yourself into trouble with these very quickly. So, proceed with caution. All right, now we get into the super exciting world of securities regulation. Um, if you make it through this and you're still awake, get a sweat equity JD. So this is another area where founders sort of get into trouble. Everything you're selling is a security, and because it's a security, you have to think about who's regulating the security, and that's always going to be the feds, and very often will be the states. So terms you don't need to know necessarily. For the feds, it's the Securities Act of 1933. For states, we're talking about blue sky laws. Again, this is with the states, it's in addition to, not in place of federal law. In some cases, federal law actually preempts the state blue sky law. But even then, there's a but, because even though the states can't regulate you, they still want you to do some filings. So it's complicated is the point. And each state has their own law. And this applies to every state where you're selling. So if you've got investors in 10 states, you have to be aware of the blue sky laws in each of those 10 states. And so again, even if you're using one of these exemptions, federal exemptions, we'll talk about in a minute, that says it preempts state law, you may have to do a notice filing in that state. So every state where you've sold the security, even in an exempted offering, you need to make sure that you don't have to do a notice filing. It's gotten to the point where I think more states than not, you do have to do a notice filing. So it's something that you don't want to be, you want to take seriously. So again, the idea here is that, what the securities laws are meant to do is to protect, little grandmas in Wichita from having their money stolen by some, swindler in the big city selling trash stocks, right? And so the idea is that if somebody is, a sophisticated investor, you don't have to worry about them as much, right? If they're a sophisticated investor who's wealthy and not going to make smart investment decisions, then we don't care about them as much. If we have reason to be concerned about their level of sophistication, then we become very paternalistic, and we want to make sure that those people, aren't wiped clean. And so again, the default rule, like we talked about, that's that you have to register. There is a rule 4A2 under the Securities Act that exempts private placements, but the rule that exempts private placements is basically says private places are exempted, but it doesn't tell you what a private placement is. And it doesn't really give you any guidance about how to figure out what a private placement is. And so where you end up is with Reg D. So in response to not giving a lot of guidance through 4A2, the SEC came up with Reg D, which you may hear about. And what this is, these are safe harbors. So if you comply with any of the rules of Reg D, you are presumed to be a private placement. And if you're presumed to be a private placement, then under 4A2, you're exempted from registration. And so what this does is it the registration process is a very costly, time-intensive process. If you follow these exemptions, it dramatically reduces the cost and effort it takes you to sell your security. And this becomes important to you really because of the but that you see underlined, italicized, and bolded in the middle of the page. So there's rules about general solicitation, and we can talk about what that is if you really want to. But the question that everybody has is, can I sell to non-accredited investors? So taking a step back, an accredited investor is a test that's been divined by the SEC that basically determines, somebody who meets certain qualifications is deemed accredited, and that means they're sophisticated, and that means they can fend for themselves. If they can fend for themselves, that makes your life a lot easier, right? And so accredited is $200,000 in salary for each of the last 2 years with a reasonable expectation of making it in the current year, $1 million of assets excluding their house, or combined with their spouse, $300,000 of income. Oh, I can't remember that. Of course, I'm going to have a senior moment about what the asset test is, but it's a couple $1,000,000 probably, $1.5 million. There's some other people that are deemed accredited because of their professions. Though that's a very defined list. It's not like a smell test. It's a defined list of people who count. For your purposes, you're really going to be focused on, their salary or their assets. And it is true that you are permitted to sell to non-accredited investors under this rule 506B, which is the most common rule that people use. However, again, what falls after the but is the most important thing. It requires additional disclosures. And so what that means for you is that your round, which I said was very cost effective, goes from being very cost effective to absurdly expensive. And that's if you have even one non-accredited investor. So if our clients come to us and they, say, well, most everybody's gonna be accredited, but I really want my best friend to get into the deal because, he or she's been with me the whole time, they're not accredited, but like they know me, yada, yada, yada. It's almost never worth it because that person is probably not going to put enough money in to even pay for the additional material you're going to have to produce in order to satisfy the exemption, right? And so again, this is the sort of bad news to most people. And this is another area we see people mess up when they don't talk to lawyers, initially. Letting non-accrediteds in really changes the calculus for all of your financing rounds. So as much as I sort of hate to say it, it's best just not to even go there. If you happen to have $500,000 of non-accrediteds that want to come in, then let's have a conversation about it. But really, like it very rarely, and I mean, effectively never makes sense to bring non-accrediteds in because of the additional cost it takes to do the round. And I had intended to go through some of this, but it's really not that interesting to you. This is stuff that you want to talk to your lawyer about. For the most part, what you really want to be focused on is doing a 506B round with all accredited investors. And the effect of that is it preempts state law. You may have to do some notice filings in the state, but you don't have to do a separate set of security compliance in the state beyond just a notice filing. You can, for your purposes, you're gonna be able to raise all the money that you want. You're going to be able to take money in from all the investors that you want. You're not able to generally solicit. That's construed pretty broadly. You're not obviously going to be able to put a billboard up on the highway, but at the same time, you're going to be able to talk to investors who you've just met. Uh, again, it's sort of a gray area, but it's a gray area that has never really been challenged and never really been an issue. So effectively, you're going to be able to do what you want to do. And from a security compliance perspective, you're talking probably less than a couple of $1,000 versus if you bring in even one not accredited, that number probably is 10x at least, if not more. So again, hate to be the bearer of bad news, but tell your parents and your friends that they can't participate unless they're wealthy. And that's it. This is a little bit on us at Wigan X. We can talk about that later. But with that, I'll pause and I think I probably threw a lot at you pretty quickly. So if you have any questions, feel free to fire away.
I'll just say thanks, Len. I've sat through a few different presentations in my time running Founder Institute, but I still learned some new stuff there. And you're the first person to really break down kind of difference between when you can do the cost difference. I did not know that level of detail between for bringing in a non-accredited investor. And I was just listening to someone I respect being like, oh, hey, this is why you definitely want to, get all your friends and family in. And I'm like, hey, I felt questionable about it, but thank you for letting me have some more detailed information I can go back to her on and say, yeah, maybe you should rethink that. So thanks.
Well, it's funny because it depends on how much you're going to raise,
Yeah.
right? I mean, if you're going to, and I said $500,000, and that was inflated significantly, but it realistically is going to cost you most likely between $10,000 and $30,000 to comply with the additional requirements. And it's again, even if you're raising 50, you net 20, but is it really worth it, right? Like that $20,000 in the grand scheme of things is that's not going to be the difference between success and failure. It's going to be more people on your cap table. It's more people that these are people who tend to be more sensitive to loss, right? And so, do you really want to lose your friend's money, right? I mean, we're all going to be successful, but some of us won't be. These tend to be people who, and I don't want to paint with too broad of a brush, but a lot of times they tend to be pretty high maintenance because they've given you money and they're very anxious to get it back. And so really it just, it almost never makes sense if you don't, if the, number of folks coming in is not so significant, that it sort of evens out. Now, listen, there's exceptions too, right? I mean, one thing that we see all the time is somebody who doesn't have a job because their parents are really wealthy and, their parents want to give them the money to do it and their risk of loss is very high. Maybe you make exceptions depending on what sort of money is coming in, but or they'll go into an LLC with their parents, and that means that the LLC won't be accredited, because they're in it, and so you still have these same concerns. So there's an exception for everything, but my rule of thumb is just stay away if you can.
I do not want to monopolize the time though. So founders, please. Yeah, Jane, go for it.
Oh, yeah.
This is a super basic question. Does this apply to raising money from angels?
Yeah, everybody, anybody.
Everybody.
I mean, angels are generally going to be accredited. I mean, true angels are generally going to be accredited. But yeah, I mean, it's anybody, if they're an angel,
So friends, family as well.
everybody.
Everybody. Okay.
Yeah.
I have a quick question. I can't find raise hand for some reason.
No problem.
Yeah.
Go for it, George.
Yeah.
We're a small enough group. Just go. Yeah.
Len, thanks for the information. Quick question: whose job it is to make sure that the investor is accredited? Just by asking, "Hey, are you accredited?" He says yes, and you move on, or is there a process involved?
Yes, that's a really not simple question, even though it sounds like it should be, right? So let's see, I think it's, where is it? There you go. So if you look at verification, so 506B, which is the exemption that I'm pushing you to use, because that's the one where if you don't take any accredited or excuse me, non-accredited investors, it's the easiest. Then you can take the investor's word. Now, if you have a suspicion that the person's not accredited, that you can't bury your head in the sand. But if somebody's holding themselves out to be a venture investor, there's nothing that there's no internet footprint that indicates that they're not. They're going to sign representations in the SAFE or whatever financing documents. They are accredited, and sometimes you'll do an accredited investor questionnaire where they have to sort of affirmatively say, without verification, but they just sort of have to like affirmatively attest to why they're accredited. And that's sufficient for 506B. 506C, that's where you have to actually verify. And so you have, and that's not just asking and having them sign something. That's actually, going through a process to verify. And typically in those cases, you're going to hire a third party. And there's a bunch of them that around now, but you'll hire a third party. They'll ask for certain documents, certain attestations, maybe a CPA's letter or something like that, and they'll confirm for you that the person is accredited.
Makes sense. Thank you.
But again, I just to be clear though, if you do the 506B, which is the one that is super founder friendly, then you don't have to do anything more than get some reps that they say they're accredited. And I should say too that if you have questions outside of the financing space, feel free to bring those too. I sort of intended that whatever we didn't cover was fair game as well. So don't be bashful if there's some other issue, employment, founder related, IP, whatever you need. And I'll put that up too. So if you're bashful, you can grab my email and shoot me an email. And I'm happy to jump on the phone and talk to you there as well.
Yeah, that's appreciated. I know though we've got some questions here. Patty.
Are there any like guidelines or steps that you try to follow when you're trying to decide if you're bringing someone on as potentially either a employee or a co-founder? Like what are the kind of key parts of your decision like that you should pay attention to? Is it like, should you focus on what they're bringing value wise? Should you focus on like how it affects like your budget and how much money you've raised? Like what is there any sort of way to kind of differentiate?
Well, so from a legal perspective, there's not much, right? But I think from a practical perspective, everything that you just said and more, right? I mean, I'm sure Reed's got thoughts on this too, but your cap table and your cash balance are precious when you're in the early stage, and you want to do all that you can to manage those finite resources. And so being judicious about what you're giving away, whether it's in terms of equity or in terms of salary, is super important. Obviously I'd have everybody on a vesting schedule. I mean, nobody, including you, more symbolically than anything else, but nobody should not be vesting. Everybody should be vesting. Even advisors, they may not have a cliff, they may have a shorter time frame, but we push to even have advisors vesting. Just because everyone's all fired up, in the beginning, and everybody's all willing to work for no cash and just equity, but after a few months of not getting paid, people's tunes tend to change. So super important to make sure that everybody's vesting. Um, and then just, from my own personal experience, it's, I think there it can be sort of seductive to hire people just so that you have a bigger team and you feel like there's, being a founder is pretty lonely and or it can be. And so it's nice to have other, folks in the foxhole with you. Um, but I would just make sure that, everyone's got a role and a skill set that they're bringing to the table and some real value that they can add. Because again, it, fundraising can be tough. Getting to revenue is tough. And that cap table is, only has so many pie pieces. You can subdivide it a lot, but you still only have so many pie pieces at the end of the day. And so, it's hard when you waste any of it on somebody who doesn't add sufficient value.
Okay, thank you.
And Nick, you had a question. Do you want to just ask, or I can read it off the chat if you.
Yeah, Reed, go ahead.
Yeah. So Nick was just asking in the chat, and you touched upon this, I think, but about the pre-existing relationship with unaccredited I think he means well, actually, so he says, don't we have to have a pre-existing relationship with the unaccredited investor if it's a 506B?
Yes. So you should never take money from an unaccredited investor who you don't have a pre-existing relationship with, ever, under any circumstances.
Yeah.
But yeah, but even if that doesn't change anything, right? Like, yes, you do have to have a pre-existing relationship with the person for it to be under 506B, but it doesn't but even if you do, it doesn't change what you're required to do in order to comply with 506B. So, um, even if it's your best friend, who, is your war buddy who, you pulled off of a landmine, like, you still have to do the same disclosures. And so, um, it's so, yeah, you do have to have an pre-existing relationship, but it doesn't matter, practically speaking, in terms of what you've got to do to get over the safe harbor hurdle. And then, so I saw Brian put accredited.
This is, some language that he had in a business contract, he said. I don't know if it's a question or if it's just a,
Yeah, so I mean, like,
No, it
so
wasn't
this
a
is pretty,
question, just to share if anyone.
yeah, this is pretty standard. I mean, this first, to sort of break it down, like this first part of the language is really getting to sophistication, but the real teeth starts after the first period, which is all the way like 2/3 down. And that's that they're a quoted accredited investor under Reg D. And that's where you get to the uh, income and asset tests that apply. And I sort of brushed over it quickly, but there's different tests that apply to individuals and then businesses. And so the example I used was if you have an LLC and you have one accredited and one unaccredited investor, unless you meet the separate LLC test, that's an unaccredited investor, right? If there's even one, it blows it for the rest. So you can have 100 accredited investors and one unaccredited investor. And if it doesn't meet the separate test for an LLC to be deemed accredited, then, it's blown for them too.
and just to be clear, it's income or assets, right? It's not both.
Yeah. Income or assets. That's right. And then for entities, it's a little bit different. I think LLCs, it's 5 million in assets. Obviously, there's not an income test. There's, it varies depending on the type of entity. Trusts have different guidelines, et cetera. But, the basic gist is that there's no way around the unaccredited, you can't, you can't avoid it. If someone's unaccredited, unless some accredited investor is going to put a ton of cash into an entity, that person is going to bring the whole thing into the unaccredited land.
Yeah.
Employment issues, IP issues? Anyone?
I had another question actually.
Okay, yeah.
Where would you put, so my IP is actually licensed from the original people who created it, and they're no longer invested in running a company selling it because it's very hard to do so and can be soul sucking. And so where would you put that in terms of like forming kind of your cap table and also like the legal breakdown of your company? Like, do you have any experience or words of wisdom in kind of the
So just,
breakdown of how it would affect?
yeah, sorry. So just so I understand, company A had some IP, and then your company came along. Company A has decided they're not going to operate anymore, but they're going to stay a company and they're going to stay in business, or they're going to stay open. And you're licensing from that company the right to use their IP. Is that right?
Yes.
So, I mean, technically that doesn't go anywhere on your cap table unless part of the license deal is that you're giving them equity, right? I mean, if you gave equity in your company as part of the license, fee, then you'd have to list them on the cap table the same as any other shareholder based on the amount of shares that they own. Or if you did it to a safe or something like that, you'd have to list them as a convertible instrument. Um, but from a capital perspective, it doesn't go anywhere. That is something that you're going to want to make sure comes out in diligence, and it will. I mean, you know, it probably makes sense to sort of voluntarily talk about that with your uh well, it's funny. People are gonna have different opinions about that. My well, I don't know if you hear it coming, but we've got pitter pattering of feet and yelling at daddy. I think my wife caught him. Um uh the investors tend to be pretty particular about your IP and how you control it and who else can, there's this fear, right? That, if you don't have exclusive dominion over your IP, that somebody else can just start the company and do the same thing that you're doing, which of course is not, it's a lot easier said than done, right? Two people could have the exact same IP. One could be a raging success and one could be a horrific failure. And there's a lot more that goes to just the IP itself. That said, investors' point of view is that they want to make sure that if the IP is core to your business, that you have complete control over it. So my view, which, and it's, again, this is conservative and other lawyers may tell you differently. My view is that's an important fact for someone's investment decision. So you have to tell them that as part of, and again, you have to make a big deal about it. You don't have to, get a bullhorn and yell it at them. But, when you're talking to your investors, even for a safer convertible note, I would make sure that they understand where your IP comes from. I mean, what you don't want to happen is at some point down the line, things get a little bit rocky, and then they find out that, oh, wait a minute, you don't own the IP, you only license it, and then it becomes trauma. So my point of view, and it's admittedly a little bit conservative, but I really actually do think it's right, is that you're supposed to give an investor all the information that may be material to their investment decision, and that is material information. So whether that, if that shows up in a pitch deck, even better. But I would make sure at some point that, before you take the money, that they understand how it is that you come in possession of the IP and what your rights are with respect to it.
And
Okay,
just
thank you.
on that, because Patty, like it's been a little while since we talked, so maybe like more has been firmed up since then. But I think in this particular case, and I it could just be potentially interesting for a broader conversation, not just specific, but like you were talking with the, sort of like former, founders of the company about potential ways to structure it. This seems like it's like one potential. I don't know, like if it's been locked in as the one, but I'm just wondering, Len, like from your perspective, like,
If you can own it,
yeah,
right? I mean, because even if you have an exclusive license where you effectively control everything about the IP and you're the only people who can exploit being more of a technical term than a non-technical term here. it doesn't matter to an investor, right? Investors, they're like, everything is very quick, right? They make quick decisions. It's a lot of thin slicing. And so licenses require explanation, right? A license means you don't own it, means you have certain rights in it. Now you may have all of the rights in it, but you don't, but that's something that has to be explained. So my view is that anything that you can do to maximize, or well, said a different way, anything that you can do so that you are the owner of the IP and you can truthfully say you own the IP, that's what I would do personally. Because when you get to diligence, when you get to, investor pitches, it just is going to make everything that much easier for you. Now, you can't force them to sell it to you, right? And so if all they're willing to do is give you a license, then you take what you can get. And if you can do the business, particularly if it's a license where you do control everything and it's in perpetuity and there's not a lot of risk, then you just have to have a very tight elevator pitch that explains it. But it's I mean, I from where I sit, it's work. You can work around it. But I don't what your thoughts are, Reed.
Well, I want to I don't want to get too into the weeds here, but I am curious on structure, and because it comes back maybe, and I don't, to the accredited investor aspect. So say hey, my friends, created this company. I know them. I think there's a lot of potential here. They're like, not so much. I want to acquire the IP, the assets, everything they have, but I don't have cash, right? So and they're going to want something.
Oh, I see what you're saying. Can I, oh, that's that Reed. That's the law school exam, man. That's good stuff. Yeah. Like, can you give them stock for the IP? That's the right. Yeah. And I mean, yeah, that's a really great question. And the answer is, if they're not accredited investors, then you're going to have to deal with them as non-accredited investors. Because you're right, that's a great question, but it's a really, really good question. That's exactly right. You're selling, like, it doesn't seem like it because it's not cash, but you're selling securities in your company for that IP. It's an, in-kind transfer, and the rules still apply.
I mean, so back, and I was probably not doing this in the way, but back in my M&A days, when we were doing M&A transactions, there'd be milestone-based earn-out kinds of things. Rather than equity, would you be able to maybe do something like that? So there's no cash up front necessarily, but it's sort of an equity kind of it's a stake in the earnings, but is that a way potentially around the accredited investor?
100%. Yep. 100%. Where you, if like a contingent payment, right? Like if you'll give X% of, the first $1 million in revenue, and then, or some lifetime royalty or whatever. Absolutely. That you can certainly, if they're willing to, bypass the equity and they're willing to take it in, some sort of structured cash payment, then yeah, that would get around the accredited investor issues.
And last one on this, I promise, but I'm just, what about warrants for that? Could I issue them warrants to no?
It's a security.
Okay, warrants are security. Got it.
Okay. Yeah, even if it's a penny warrant, you're effectively giving them a security for that ownership.
Got it. Okay.
I have a question about basis, and as it may or may not apply to a corporate situation. So
I will tell you that I'm probably not going to know the answer to it, but we can try.
Okay. So I have a crap ton of IP that I have developed for my business, in excess of 1 million lines of code in our software. I've developed that over a long period of time, which predates the actual formation of the company. But now the company is what it's here. It's making money. We're profitable. How do I account for that cost basis, or is it just simply I've got the shares, I own the company at the moment, and that it is what it is?
Are you a sole founder?
Yes.
When did you form the business?
Incorporated Delaware C Corp in November of 23.
Do you have a CPA?
Yes, but
Okay.
I don't know that they did anything.
Yeah. So I think I think what's done is done, unfortunately. Um, but so there's a few ways you can handle something like that. Um, and it's easier when you're a single founder, right? But you can assign a value to it, and that becomes the value that you paid for your shares, right? Which, to your point about basis, like if you can assign a $50,000, mostly, most times when you form a Delaware C corp and you follow the sort of standard practice, you're paying like, somewhere between, $500 and $600 for your shares, right? But if, and I wouldn't do it yourself, but if you had a CPA that sort of assisted you through the process of, putting a value on that, I think you could take the position that, you contributed $60,000 of value in exchange for your shares, so that your shares, had a $60,000 basis in it, which means that you wouldn't pay taxes on the first $60,000. So the bad news is, I think it's probably too late. You should definitely talk to your CPA about it. They can tell you, what's still available to you. The good news is that it's probably not going to be more than $100,000, if even that much. And so it's probably not going to matter in the grand scheme of things, right? I mean, if you're a sole founder and you maintain a large stake in your business, it's going to have to be a big success in order for you really, most likely, particularly if you're going the venture route, it's going to need to be a big success in order to like really reap the rewards of it. And at that point, $100,000 is not going to matter that much to you, practically speaking.
We got a question from George here too.
Yeah, I have a question around the employees' options, and
Yep.
if there's a way to kind of, maybe an easy way to just grant options to employees, or you should ask what's the proper way of doing that.
Yeah. So, it's not hard to do, but there are some rules. I don't know if how familiar you are with or if you've heard the term a 409A valuation, but
Okay.
409A is a section of the tax code that deals with equity compensation in exchange for services. And if you're selling options, as with everything in law, there's an exception for every rule. But the basic rule is that you have to have a independent party perform a 409A valuation. And what that does is it's not the valuation that you raise money at. Like, so it'll be a low valuation, and you shouldn't get too hung up if you have a very low 409A, but you want to raise it at a much higher valuation. Every investor knows that there's no relationship between the two, but you need to go to a third party, credited, or not accredited, but a legitimate, valuation specialist who, who can come up with, and tell you what your, fair market value per share is. And then you issue it at that. And you can do an option plan through, I think Clerky does one, Carta probably has got one.
Yeah,
Like those are all pretty
I
simple
do
ways
have
to
one.
do it.
Yeah.
And if you use, for the, I think people get in trouble with it because there's actually securities laws you need to comply with too for those option plans. They don't really get talked about as much, and you don't really, like people get dinged far less often for those, but they're there and you really should comply with them. And some investors are really going to be on top of that. So, it's one of those things. I think you run a risk of getting in trouble if you don't do it with an attorney, because it is a little bit complicated. But if you are like dead set on doing it yourself, I wouldn't do it outside of a system. I would do it in a system, and I would make sure that you got a 409A valuation. And if you're on Carta, depending on your level, most of those come with like a free 409A, and you should do it based off of that 409A value.
I guess the right question is, should I be issuing stock options early on, or is that like to kind of, as an employee, founding employees, compensation, or is it something I should be thinking about later on?
I mean, I'm sure Reed's got thoughts on this too. This is really tricky, right? Because, the laws and I mean this broadly, securities laws, employment law, it's all set up for, again, in a very protectionist way and intended for bigger businesses. They're not really intended for startups. And so, for example, there are minimum wage laws in every state and federally. You can't avoid those laws with equity. That's cash. You have to pay cash. So if you're in, but most people aren't going to have that cash, right? And so, at least starting out. And so if you're hiring somebody, but you're hiring them with equity and no cash, technically you're in violation of the minimum wage laws, right? And so, it's hard, right? Like these are hard decisions that people make, and they sort of, they roll the dice on often because there's just no other way to do it. And,
Right.
as a lawyer, we're not allowed to advise you to break the law, but, I can tell you that, like, the decision to pay somebody with equity over cash when you don't have the cash is something that's happening every day because, there's just no other way around it. Now, you could conceivably end up in a very uncomfortable position because of it, and personally, because employment compensation is the one place where the corporate limit liability protection doesn't extend, right? So if you're the equity owner of a business and you're in violation of the wage and hour laws, you can be personally responsible for that. Plus they have like all sorts of nasty like multipliers in some states where you can get like triple the value and all sorts of punitive penalties to encourage you not to, not to get too cute. Now, again, these are meant for people who owned the company store in the 1940s and, are taking advantage of, people in the factories. They're not meant for, young startup founders who are trying to get a business off the ground, but they apply all the same.
Right. Okay. Thank you.
No problem.
Okay, we're getting pretty close to 8 o'clock. So I think this should probably be sort of the wrapping up time. Len, really appreciate you coming in. Also, I know we don't have anything to talk about yet, but so we have been working with Wigan for a number of 3 cohorts now.
Yeah.
But really, I love the relationship. Been working with Jack a little bit, and Len and Sean to also come up with sort of like a different package. There is the incorporation package that they offer, and it's still very valid. But we're also trying to work to find another sort of like offering for FI to be able to have high quality lawyers at your beck and call who can help you with all of this very detailed stuff. I mean, and when you were asking like if I have an opinion on that, for some things, yes, but for most of this, it's like, no, like I am very much aware that I am not the right expert. I know that there are things that people do. I have no idea which ones are the ones though that people do that are roughly probably okay and that you are likely to be able to sort of like do, and the ones that are like, oh, absolutely don't do this. Like it's very very, very hard as even a interested party who's been in the space for a while, who's worked with a lot of companies. It's still very hard for me to know like what are the right ways to go about it.
Totally. Well, so I would say 2 things. One, it is really hard to unring a bell. And so, if you're in a situation that you feel uncomfortable, or you're sort of, getting to you feel like you might be doing something that you shouldn't do. Like we're here, and I mean, we Wigan, to be supportive of this cohort. So you should always feel free to reach out, right? I mean, my email's here. I'm sure you can find Jackson Shams either on our website. I'm sure Reed's got it. You've probably gotten some other presentations. Reach out to any of us. Don't hesitate. I mean, we're here to be helpful. So if you've got questions, it's, I just believe strongly that, and part of it was I was a former founder myself before I got back into law. I had a little hiatus. And it's hard, right? Like it's complicated. This is stuff that's not, you can read a bunch of blogs and it's not going to make it, still not going to make any sense. And so, we want to reduce the friction as best we can. So feel free to use this as a resource. We're happy to help. That's one, two. And then what Reed said, if there are things that you feel like as founders that you really could use some help with, but you're worried about the expense of it, tell Reed and then let Reed and us talk about it, and we'll figure out a way to package it. Right. I mean, this is, generally speaking, and I think this goes for any of our startup clients, even outside of FI, we want to be a resource, right? We're not here to put you out of business. Right? Like, we're not going to make enough money off of any new startup to justify the relationship, right? Like these relationships are interesting to us when we can keep you around, for a bunch of financing rounds, do your exit, then you become really wealthy, and then we become the lawyer for your venture fund, and we do all your financings, and then you're really wealthy, so you got to do trust and estates work, and you got to, give up all your money to all your kids. Like that's when you become valuable to us. So if you blow it early on, you're no good. So, we're here and we're incentivized to make sure that you're set up for the long run. And so if there's anything that you need, I talk to Reed about it and let's have a conversation, because I'm sure we can figure out a way to make sure, as frictionless as possible that you're getting, what you need to be successful.
Yeah, please. And thank you, Len.
And I see this, and yeah, and I'll set out, I'll send you the PowerPoint, and you can send it around.
Perfect. Awesome. Okay. I'm going to say thank you very much, Len. Go, run after some of those pitter
I
patter
will.
feet. And
Yes.
yeah, founders. Also, just again, I know I say this all the time. You're the quietest group of founders I've had. Like normally, I have like so many questions. I'm so like waiting for like people like keep me on for like an hour after the end of the call. You guys are quiet, but I'm giving you like another option here if you have any questions about Founder Institute to stick around. But Len, thank you very much. We'll
Cool.
be in touch.
Awesome.
Have a good rest
Thanks,
of your day.
everybody. Good luck. Yeah, we'll see
Thanks,
you soon.
Glenn.
Thanks, everyone. Bye-bye.
Thanks.
Yeah, thank you.
All right, bye, guys.